Hello, welcome everybody. Please feel free to grab a seat. Seats have tended to fill up fairly quickly in these public hearings, so if you'd like to get a seat, I'd say get one now.
Should we, since this is like church sometimes, see if we can get people to move over so that people come in later rather than having meetings?
If you'd like to move, you can move to the center. On behalf of the Comptroller, Justin P. Wilson, I'd like to welcome you to today's public hearing in Jackson. This is our third of 3 public hearings on this important issue. The purpose of why we're here today is really quite simple. In this past session of the 109th General Assembly, a bill was introduced that would have allowed charges to inspect public records. And that bill was taken off notice to allow for the Office of Open Records Counsel to report on this issue and gather public input. So why we're here today is really a part of that process to gather public input about how folks feel about this. And we really want to hear from you. The legislature has told us they want to hear from a variety of folks, whether they're citizens, media, government entities. We really want to know what you have to say about this important issue. Now, it's important to note that no decisions are going to be made here today. This is simply a public hearing to allow you to have the time to provide comments to us. And we ask, because there are a number of different viewpoints in this room, that you try to be respectful of others as they communicate their point of view. Please no clapping, hollering, hooting, and just try to be respectful. And we know that that probably goes without saying. We ask that of you today.
You're in West Tennessee now, so.
I want to just briefly describe the process that we'll be following. As you all know, many of you have signed up ahead of time to speak, and folks will be recognized in the order that they signed up. And we'll call the person who's going to speak as well as the 2 people who will be next. And those 2 folks can sort of sit in these chairs almost like an on-deck circle. And then we'll continue through that process until all folks have been recognized to speak. Right now we have about 15 people who have asked to speak, so that allows enough time for everyone to have 5 minutes today. During those 5 minutes, you will be timed by Rudy Basildua from the Comptroller's office. When you have 30 seconds left to speak, he'll hold up a sign. And then again, at the end of your time, you'll see another sign. Time's up, and Rudy has a bell he'll ring to remind you that that's the case. This is a well-coordinated operation by this point. We'd also like to tell you that all of the comments that are made here today will be recorded. This is an audio recording device here, and then they'll be posted onto YouTube in the form of that audio recording. In fact, the previous 2 public hearings in Knoxville and Nashville are already posted on YouTube, and you're welcome to listen to any of those comments that were made over the last 2 days. And that's the Comptroller's YouTube channel. In fact, I Googled public hearing Knoxville before I came in here today, and it was one of the very first things that popped up as a video option. So, very easy to find. I would like to just take a moment to recognize Senator Ed Jackson from Jackson, who is here today. Of course, you know that the legislature will ultimately make this decision about charging for inspecting public records, and we appreciate him being here to gather and listen to what you all have to say about this issue. Yes. Now, if you choose not to speak, of course, we still would like to hear from you. And there's a number of ways you can do that. We still have surveys that are available for both citizens and government entities, which can be found on the Open Records Council's website, links to those surveys. And you can also email the office at comments.open.records@cot.tn.gov. And we'll repeat that address again at the end of this meeting. It's also on one of the handouts that was provided at the back of the room. We will continue to accept comments via email and those survey responses through the end of the month, September 30th. So please, if you have additional comments that you'd like to share, send those by that date. Just a quick note of housekeeping. Bathrooms are just out this door and to the left. They're sort of behind us here, so they're on the other side of this wall, more or less, if you need to use the restroom. And now I'd like to recognize Ann Butterworth, our Office of Open Records Counsel, to provide just a few quick comments. Thank you.
One of the things that I've liked best about this week has been being able to put faces with names, because I have met many of the people that previously have only known through email or phone conversations. The reason we're here today is because of the Tennessee Public Records Act. Access to public records is provided for by legislation enacted by the General Assembly. And we refer to it in Tennessee as the Tennessee Public Records Act, and that is found in Tennessee Code Annotated, Title 10, Chapter 7, Section 5. This hearing and the Tennessee Public Records Act applies to Tennessee governmental records. And we will not be dealing today with federal records that are governed by the Freedom of Information Act. The Public Records Act grants citizens the right to inspect and to receive a copy or duplicate of public records that have not been specifically made confidential or closed to public inspection. It is important to note that taxpayer status is not a prerequisite to the right to inspect or to receive a duplicate. Many entities who are governed by the Tennessee Public Records Act do not receive any form of tax revenue, such as a utility district, which is funded by revenues from its customer base. Generally speaking, a requester may not be required to put a request to inspect in writing, and cannot be required to disclose the purpose or motivation behind their request. A custodian may not deny a Tennessee citizen the right to inspect an open public record on the basis that the requester does not live within their community or is not a customer or client of the entity. The Tennessee Public Records Act is not the only means by which government records are made available. Other provisions of law, such as the Open Meetings Act, which makes minutes of meetings open for public inspection, you can find many places where records will be made available. The Tennessee Public Records Act imposes upon custodians the obligation to make records available promptly. And although the Records Act starts with the presumption that records will be available and open, it is a custodial duty to ensure that one of the more than 350 exemptions to the Public Records Act has not been triggered. A record custodian is obligated to maintain as confidential any record or information designated as such, and may not permit public inspection of any such record. The exemptions to the Open Records Act are not found in a single section of the code, but are found throughout the statutes at not only the state but also federal level by court cases, court rules, and regulations. A record custodian under current law is not permitted to charge for staff time locating records and preparing them for public viewing when the request is solely for inspection. These costs, however, may be passed on if the requester asks for a copy or a duplicate. Labor and charges are currently governed by the Schedule of Reasonable Charges established by the Office of Open Records Counsel with advice and input from the Advisory Committee on Open Government. We have several members of our Advisory Committee, and I would ask at this time if they would raise their hands. These are folks who are offering their time and advice to assist the Office of Open Records Counsel in dealing with the variety of issues that come before us. As was indicated previously, to please be respectful of the comments made by others. A few people have said, well, I don't want to speak if the people before me have already said what I think. And we appreciate people not being duplicative of comments. However, it's also very important, if you are willing to do so, to come on up and say, I agree with the comments of Mr. Dunn, and then sit back down, because that will get into the record that there are additional people of the same opinion. With that being said, if there are no questions at this point from anyone, then our first commenter will be Mr. Joe Sano. Is Barbara Gay here, please? And Steve Kaufman. And then Mr. Michael Williams.
Thank you very much. I appreciate it. And I'm looking forward to this meeting. I must say I am charged up because I watched 5 hours last night on the debates in the presidential debates. I am Joe Sano in Memphis, Tennessee. I run MemphisShallBeInformed.com. Just to give you a brief history, I was an engineer. I am an engineer. I ran a company for 40 years, and then when I retired, my wife's first question was, when are you going to accompany me to the grocery store? And I knew I had to get another occupation, and I became an advocate for open records. And I've been at it 10 years, and I have had every different kind of experience. I filed 6 lawsuits pro se, won 5 of them in Chancery Court, and I am not giving up on this. This is one of the most important issues, and all you need to do is look at Washington, D.C. and see the IRS and see the Benghazi thing and see what they're holding back from the Iranian deal, and you know how important open records are. Just to give you some example, in Memphis, we've had some that are very good and most that are terrible. I asked, for instance, the old city school system, Memphis city school system, to see a social studies book. They refused for a while, and finally they let me have it. I had to come down there. 2 people sat with me, one reading a glamour magazine and the other one reading a novel, and they brought the book in like the Gutenberg Bible and set it down. And then when I wanted to make a copy of a page, they said, "Oh no, you can't do that. That's you'll be sued." It's the most ridiculous thing I ever heard. Now, as for these 5 questions, which I answered them: number 1, no; number 2, no; number 3, no; number 4, no; number 5, no. It is outrageous to think that you would charge for me to just go look at the records. I mean, it is obviously an attempt to shut the door on open records. I will refer you to, this problem can be solved in 2 ways. Number 1, if from the top, for instance, I can get almost anything I want from Shelby County government, because Mayor Luttrell and Harvey Kennedy are open, and they just send stuff immediately. You go down to the city of Memphis, and they, even though you're supposed to be able, during business hours, to be in the building, they will not allow you in unless you have an appointment, which is in violation of the law. And so try to get an appointment, and nobody will talk to you or return your calls or emails. Same thing is true of the Shelby County school system. So that is a real problem. I refer you to Mike Carpenter's, the mayor, A.C. Wharton of Memphis, asked Mike Carpenter, who's a former county commissioner, is now executive director of the Plow Foundation in Memphis, and he asked him for the review of public records and transparency in government. It's a very interesting document, and I will post it online in my MemphisShallBeInformed.com. But basically, he says that kind of thing. It comes from the top. You can solve these problems if the mayors will allow it. And then, but they are very, what we have now is a 19th century, barely 20th century system of record keeping. We need to go, as Mike indicates in here, we need to go to the 21st century, and we need to start out with new record keeping so that the records are immediately redacted or not put with redacted material in there, so that all records could be created. We got redacted records and those that are available for the public, and those should be put online immediately as soon as they're created. The technology nowadays with the cloud will allow this to be done, and this will open up records to the public and will allow the public to stay informed and to know what the politicians are doing. So I ask you to look at that and ask you to keep that in mind that time's up. Okay, thank you very much.
Mr. Tom Britt.
Good afternoon. My name is Steve Kaufman. I'm the editor of the Jackson Sun and JacksonSun.com, the daily newspaper and website in Jackson, Tennessee. First off, I'd like to welcome you to Jackson if you're visiting here, and I'd like to thank you for scheduling this hearing in Jackson, offering the citizens of West Tennessee an opportunity to be heard on this important question. Senator Jackson, I'd particularly like to thank you for your presence here, recognizing the importance of this issue and the decisions to be made. I'd like to address the question of whether the Tennessee Public Records Act should permit records custodians to charge for the inspection of public records. It's my personal stance and the stance of the Jackson Sun that this should not be permitted. Charging to inspect public records would be a dramatic step away from open government, which is a foundational element of this country. Open government is part of what makes our country shine as a beacon of freedom when compared with many other countries in the world. At the most basic level, the residents of our state have already owned these public documents held by our government, and it's simply wrong to think they should have to pay to inspect those records. With taxes that we pay, we've already paid for those records, as well as for the salaries of the people who created them and for the equipment and materials used to create them. Charging a fee to inspect those records will be equivalent to levying another tax. Charging a fee would make citizens more reluctant to seek public documents, which can inform them of the actions of their government and government officials. Charging a fee would have a chilling effect on the work of journalists who act as watchdogs and accountability agents on behalf of our state's residents. Many smaller news operations simply don't have the money to pay to view public records. In recent years, the Jackson Sun has used public records to expose unhealthy water in many public swimming pools, to expose a public official who lied about his criminal background, to expose excessive travel by a public official, and to expose unfair allocation of the state's resources for economic development. The list could go on. These stories and many more put an exclamation point on the importance of unfettered access to public records without having to pay hundreds or even thousands of dollars to do so. Charging a fee to inspect public records would be another step on a slippery slope that leads to secret government and may embolden government officials with an ill intent to abuse their positions and the fee system itself. Unfortunately, we've already taken some steps on that slope by allowing government to charge fees for the duplication of records and for the labor to fulfill public records requests, systems that are implemented unfairly across the state and that should be revisited as well. In fact, the mere progression of these fee structures, from copying fees to labor fees, and now the idea of inspection fees, is evidence of how that slippery slope can play out. If we allow our government to charge to inspect public records, what will be next? I understand that there are those who may create a burden on government with nuisance records requests, but I would submit they are a small minority of those seeking records, and I would submit that may be a necessary cost of preserving open government. Open government is a bit like the First Amendment rights of free speech and freedom of the press. It can get uncomfortable and it can get messy at times, but the alternatives are much, much worse, with government restricting what we can say, what we can publish, and what we can know about its actions. Further restricting access to public records in our state is a step in the wrong direction, a step toward government that gathers even more control over our ability to gain knowledge of its business. I respectfully ask that we turn away from the idea of charging fees to inspect public records. I thank you for your interest and attention to this matter.
Good job. Thank you.
Bruce Moore.
always throws me when she calls somebody else's name.
Eddie Settle.
My name is Michael Williams. I'm the editor and publisher of the Paris Post-Intelligencer, small town daily paper up in the northeast corner of West Tennessee. And I want to say I agree totally with the comments from the first two gentlemen and with most of the comments that have been made in Knoxville and Nashville that this is a bad idea. That we already own these records as taxpayers, and to ask us to pay again to inspect our own records just does not make sense. Since most of my comments have been made, I want to concentrate on one side area I was hoping to get to, and I'm glad Senator Jackson is here because it involves the legislative process in coming up with bills. When we have bills introduced in the General Assembly to close records, sometimes they can be good bills, make common sense to close certain things. A fiscal note always has to accompany a bill. The fiscal note for these always comes back, it'll cost nothing or next to nothing for this bill to be enacted in closing records. And I would submit that that's totally wrong, that what's not being considered is what the cost is to redact the information and provide to the public the information that is still public record that we need, and that the things that we're trying to get to see. It's not the things that are closed, but the things that are open. And if there's that fiscal note that says zero leads to things like these hearings where we're trying to come up with a way to pay for the information to be redacted and then for us to be able to inspect the records is basically what's going on, because there's no problem finding a record and just letting us look at it. It's when they have to go through and take out certain things and make sure we don't see the wrong information. That's the cost involved, and the cost that this bill, this ill-advised bill, is trying to recoup at this point. That's coming after the fact and trying to recover the money that we said in the first place there was no dollars connected to this. And I submit that that's totally wrong. We need to be careful when we're considering things, when we're closing records, what the true cost will actually be to the taxpayers. Our first speaker hit the nail on the head when we had the technology to go ahead. We need to be figuring the cost. If we're going to close certain records, what is the cost of going ahead and redacting that information and having the information available so the public can see what is still public? That's a very real cost that can be calculated and needs to be considered on the front end. Do we need to pass this bill if it's going to cost this much money to create a bill to create a copy with the redacted information out so the public can see what they need to see? So that's my contention, that the system is flawed on the front end when we say there's no cost and there's actually quite a bit. So please consider that, Senator Jackson, and I hope this committee will take that back to the legislature because that's where we have a lot of problem. And if that was considered on the front end, we knew where that money was going to come from, we could create that record that the public can see everything that is public right away. There's no reason for us to be here today. Thank you very much. Appreciate it.
Good afternoon. I'm Tom Britt with WBBJ ABC 7 and CBS 7, serving most of the counties here in West Tennessee. First, let me state my personal opposition and my station's opposition to charging fees to see public records. State and local governments are agencies formed to serve its citizens in an open and a free manner without putting obstacles in the way that those who want and need and use the public information. As we've already stated, there are charges already under state law for copies or scanning of public records, and for some reasons, organizations and citizens are often prevented from taking pictures or even scanning those public records. In the age of what we all carry around now, our cell phones, everyone is a photog, and you have that opportunity to snap a photo or scan a document, which means if allowed to do so, there would be less cost to the government to do it in the beginning. We've been told by elected officials that only a few are causing problems, wanting copies of thousands of documents, costing thousands of dollars in materials, and of course hours for custodians of those records. State Representative Steve McDaniel of Lexington, who introduced, or Parker's Crossroad, who introduced the bill to charge reviewing, told one of our reporters yesterday that he did not know the amount of money such requests have cost cities and government agencies. I feel we really don't know what the cost has been for those requests. And if there is a problem, the media and the public should be provided with a detailed list of those costs. So far, that hasn't happened. It appears to me this is a form of a new tax akin to a poll tax, once used for voting. I think such charges would prevent and deter the public from seeing documents that, under law, are public and in reality owned and paid for by taxpayers. Such law would make it much more difficult for news agencies and those seeking information that should be readily available in an open and a timely manner. Public documents and information should be easily obtained without a large fee to news organizations and all residents of Tennessee. Government should be more open to accountability with less obstacles, fees, and hoops to jump through for those seeking public records of what is happening in local and state government and other public entities. And in closing also, I don't want to pay a fee to look at my deed down at the county courthouse. Thank you for your time.
Thomas O.
My name is Eddie Settles. I live in Memphis, Tennessee. I blog along with my wife with backinrivercity.com. My professional background is I was a lawyer, a CPA, and served for 9 years on the Tennessee Advisory Commission on Intergovernmental Relations. Tennessee citizens deeply distrust government at all levels. Government shoots itself in the foot on trust issues by finding new ways to keep the public from knowing. I'd like to make 3 points to support that premise. First, my experience, especially in Memphis, Tennessee, is that public officials fear public knowledge. Second point is, there is no accountability for current charges. As a CPA, I will tell you that if you allow me to charge for labor in any shape, form, or fashion, and have no one who is in a position to challenge whether those labor charges are appropriate, then I can promise you there will be no public open records provision. Third, government efficiency and public confidence is enhanced by total transparency. You've already heard from a couple of the folks who've spoken today about changing the way we create documents. Technology is already there to do that. I'd like to share with you a story to reemphasize these points. In late August, I made a public records request, late July, I made a public records request to the Shelby County Schools and requested information they had about the Hamilton County School Board versus William Haslam lawsuit to compel the state of Tennessee to pay an additional $330 million, give or take $100 million, to the local educational authorities across the state of Tennessee. I received a response almost by return email. Amazing. We have no information about anything about this lawsuit. I happened to be in Nashville a week later and went by the Davidson County Chancery Court Clerk's office and just happened to find an order that was entered the same week that the attorneys, the firm hired by the Shelby County school systems, had requested that the court exclude them from the class action certification for the lawsuit. And then 2 weeks later, as we all know if we followed it, filed a massive civil rights lawsuit against the state of Tennessee with who knows what kind of impact will occur on the premise that all school students should receive an equal outcome, not equal resources. Surely that information was somewhere within the bowels of the Shelby County school system. The next week, I asked the state attorney general if I could have a copy, either digitally or by going to their office in Memphis, of the brief in opposition that the state was going to file. General Slattery's spokesperson said, pretty simply, no. They said, if you happen to be in Nashville, we might have a copy you could examine at the state attorney general's office, but we suggest you go to the Davidson Chantry's office and spend 50 cents a page for the some 150-page brief. Ladies and gentlemen, that is an unacceptable result under any circumstances in a democracy. I do not understand how this has come to be, but I will tell you, again, by having dealt for a long time with local and state government, that when there is fear that citizens will learn things that will not redound to the benefit of the elected or appointed official, there will be ways found not to produce those documents or to make the road so far and so long and so expensive that it won't happen. So, to go along with, or to perhaps put a gloss on some of the things that some of the other folks have already said, I do not understand why we do not, in fact, put all documents, archive them with proper redaction fields at the time it was created. So in closing, if the General Assembly is interested in restoring citizens' confidence in state and local government, it will not allow imposition of charges to inspect documents and will require immediate accessibility of all digitized documents at the time of creation without charge and without exception. Thank you.
Madam Chairwoman, Senator Jackson, Sheriff Vashbinder, and other members that are here today. My name is Paul Tinkle, and I am from Martin. I grew up milking cows in Obion County, a little community called Midway, and you'll understand why I'm telling you this in a few moments. I became a disc jockey, a newsman, general manager, and now serve as president of Thunderbolt Broadcasting, and we own and operate radio stations in Weakley and Obion County. In my observation, it's clear our local radio stations and newspapers back home in Dresden and McKenzie and Union City, as well as our radio stations in West Tennessee, have a terrific working relationship with our local city and county officials at the courthouse. And I think it's fair to say that the Tennessee Public Records Act is working, and there's no need to change it. Let's leave it alone. To give you an example of how closely we work together with our local public officials back home, if our radio stations need information on a matter of importance to the public, our local community officials reach out to us and say, what can I do? Do you want me to fax it? Do you want me to email it? You want to come look at it? You want us to make you a copy? And by the way, I don't know that we've ever been charged, but we'd pay if they did. They've never, ever been burdened by us, and never have they made a burden of themselves in working with our local radio stations and newspapers. And I think it's safe to say the television stations too. These dedicated public servants who we have in Weakley and Obion counties and several other counties here in West Tennessee realize the important relationship we have in getting information to the public, information that matters to them and to our listeners and viewers and readers. Never have we ever had any discussion about being charged for inspecting public records or pulling a file for us. Our folks are helpful and they are excellent public servants. If we need copies of minutes from a county commission meeting, a docket from the sheriff's department, say an arrest warrant, if we need to see a deed, Tom Britt, or if our local officials need to talk with us, we have a relationship that's perhaps the kind of relationship that every county courthouse needs to have across the state with their local media and the general public. I mean, after all, folks, these folks are paid to do what they love to do, or they wouldn't have the job that they have. You have to be someone that loves what you do to be in public office or to work in the courthouse or to do the job at City Hall. They're all extremely helpful to us. These are people who work with and know where the information is that we need. So when we walk into the courthouse or to the city hall, we ask for something, they know right where to get it. There's never been a question about how long it takes to locate information, a file, a docket, or any other public record for that fact. These folks know right where to look because they do this every day. Clearly, our local public officials see helping us in the news media and the general public as part of their responsibilities to those who elected them to the office that they serve. The clerks who work in these positions in our counties know where the documents can be found, and they handle this in a very professional manner. And if they're with a customer and we come in, we're patient enough to let them serve the people that elected them. I understand some folks across the state would like to charge the public to get to see these records. To me, charging a fee to get or to see a public record is, well, back home, I told you a moment ago, I grew up milking cows. To me, this is like having to pay the cow for providing the milk that you've already paid for at the store. Our state and county and local governments are elected and hired to serve the people. Helping those who come to the courthouse to see or view public records provides a return on the tax dollar that they have paid already. To my thinking, setting a fee schedule or charging the time to, well, there's a lot of problems if you're thinking about doing this. And really it does appear to be a hidden tax. If debated, I'd simply say, who would regulate the time? Would this be cash only? Credit card? What are you going to do if somebody comes up there and doesn't have any money? Tennessee doesn't need to start charging people an admission price to see something they've already paid for. And let me just say this in closing. A few years ago, the late Governor Ned McWhorter, when he was Speaker of the House of Representatives, made clear that public meetings and public records should be open to the public. And if he were here today, standing in front of you, certainly he would be among those saying to you, don't charge for something twice that's already been paid for. Thank you.
Ken Welch, Nancy Spencer.
I'm Thomas Odd. I'm the county archivist for Madison County, so I am one of those record keepers that different speakers have talked about. And our job at the Madison County Archives, like in all the other county archives, in most of the counties in Tennessee, not every county has one, unfortunately, is to preserve and make available to the public those records that are considered public that have been created by public officials. Those public officials, Tom Brett, include the Register of Deeds, and you would find your deed at the Madison County Archives if you'd like to come by tomorrow and look at it. I will be there. But traditionally, any charges for any things that we provide through the county archives is only for copies. We do not charge for helping people find things, having access to those records, because those records by definition are public records. And because they are public records, we cannot charge for them, or do not feel that we should charge for them. To create a law or a mandate from the state level saying that we need to do that is not fair to all the state's county archivists and staff to try to manage that. As the previous speaker mentioned about how do you manage collecting the fees for that. If you take credit cards, there's a fee to handle credit cards for payments. I know that, and everybody else knows that. And that's more of a burden to those small county archives like ours and even smaller ones in West Tennessee. Most of the county archives in the state are managed by a very small staff. We have 3 part-time people working at the county archives in Madison County. I know some counties in the surrounding area are run by volunteers only because there's no government funds to pay for them to have it open. A lot of the counties, their records are stored in inaccessible places, inappropriate places, and because of that, those records are disappearing over time. Madison County has been fortunate to have a Public Records Commission that was created at least 15 years ago, maybe, Jack, or longer. Jack Wood is in the audience. He was on that commission at the time. And the duty of the Public Records Commission is to help the public officials to decide what happens with their public records and how to save them, preserve them, or dispose of them. There's no authority granted to that particular commission to charge for access to fees. They do approve the amount that we charge for copies, which is very nominal. We only charge 25 cents a copy as opposed to 50 cents or $1 or more that some offices charge. But anybody who wants to come to the county archives, not only in Madison County, but anywhere, probably in the state of Tennessee at least, has free access to any of those records. They will have the staff to help them look at the records themselves. And we do have some records that are technically confidential, and they are still under the control of the official that turned them over to the county archives. Many of those would have to be redacted for copies to be made available, but we have yet to have any of those requests. Most of our requests come from historians, genealogists, researchers from as far away as New Mexico. I know because I've helped a gentleman several times from New Mexico whose ancestors were in Madison County back in the day. And he is very grateful for the records that he has access to through the Madison County Archives. Coincidentally, I'm also on the Tennessee Historical Records Advisory Board as an appointee by Governor Haslam, and I appreciate the opportunity to serve in that capacity. In that capacity, we help oversee the preservation of historical records across the state, and this issue has not been brought up to that particular advisory board. I'm not sure if it would have the authority to act on this, if it's coming from the legislature itself, but it may be something that that particular board would also like to address if they have it already in Nashville. Hopefully they have. Thank you.
Jack, Louis, John, Tyson.
Hi, my name is Nancy Stinson, and I'm from White House, Tennessee, and I feel there should not be a charge for viewing. In late 2009, our home property became involved in a City of White House sewer project. Funding came through the state, and all project approvals came from them. What was going on around us did not feel right. In February 2010, I emailed the city administrator and said, "We would like to know how this has been presented to the state of Tennessee in regards to us and to our property, especially since the ERA funding is involved. Are we entitled to view these documents?" The city administrator replied, "We will get all correspondence that we have had with the state regarding this project together for you, as it is public record." She began emailing the records. None of them helped to explain our situation. 3 weeks later, she sent more records, same result. In February 2012, I viewed what was supposed to be all project records. At our city police station, I was provided 2 boxes of records that seemed to be in no particular order. Some documents were in folders, many others were not. Because of copying errors, I had to view them all over again. The next viewing was at wastewater, with many more records provided and in better order than what I'd seen at the police station. But some I'd seen at the police station were missing. The wastewater employee who made the copies, she was excellent to work with. She agreed that the records were not in good order. In January 2013, after living with sewage odor inside and surrounding our home, we mortgaged our home, hired an attorney, and I went to the state to view their records. The state records were kept in reverse chronological order and bound in thick folders. Each folder had a name like planning or construction. Right away, I found many documents containing the information we'd needed in 2010. Had we received them, they could have made all the difference in our outcome. I told an SRF staff member how I appreciated the condition of the state records and about my experience with our city. She said, "White House is supposed to have a set just like ours. They better hope that they don't get audited." Project records help to diagnose how our home was venting from the new sewer lines and help to show how our property was taken from us against state-approved plans and with no legal basis. If I'd had to pay simply to view records, I would have paid 3 times on the city level while still not receiving access to the missing documents. But without going to the state, I never would have known the documents existed. Given the broad range of conditions public records can be kept in, I don't see how a charge for viewing could ever be fair. But given our experience with the Copes Crossing project, I do know the absolute vital importance of free and open access. And I'd like to say that the records clerks, I don't believe our records clerks were involved in this at all. I have worked through a records clerk's had never ordered a single record prior to this project. I have records now. I worked through the records clerk to get those, and they're excellent. This was handled first by a city administrator, then by a police chief who was acting as city administrator, his secretary, and then the employees at wastewater. If a records clerk was involved with any of this, I didn't know about it. There was a record clerk, of course, at the state. And this also helped us the records also helped us to get a site visit from the state revolving fund, and they required the city to survey our property. When the city administrator blocked, I guess I could say he blocked it. It was offered, and then when he was spoken to, it was taken away. It was the same thing with the venting at our home. They just wouldn't address it. They just denied it. And we've been there 30 years, and having your city treat you like that and put you in danger like that, and it is the absolute most catastrophic thing we've ever lived through, and it's 6 years now. 6 years going. And sometimes when you do not have an attorney, we had an attorney maybe 9 months out of the 6 years. When you do not have an attorney, that the records are all you have. I've learned that is all you have. The information is all you have. Right now, the federal government has a pilot program. I believe it's called Access to One, Access to All. And it's sort of like others were speaking of. But this was if one person requests a record, then it goes online and everybody can have it. So I think that's a really good idea. Thank you very much for listening. Thank you.
My name is Jack Wood. I'm the Tennessee Room Librarian at the Jackson-Madison County Public Library. I've been in that position for 29 years, and our job is mainly to preserve records, to maintain the books and materials that we have, and to serve the public in helping them find whatever answers to whatever questions they have. And over the years, I've worked with just about every agency and department throughout our county and our city. I can oftentimes call the police department when we have people that are looking historically back into old accidents or wrecks or crimes. We've consulted with the public newspaper or with the Jackson Sun in trying to locate information for people. We have on microfilm Jackson newspapers going back to the 1820s, and we use them readily. The Jackson Sun frequently contacts us to help look up things that when they get a call. We consult and team up with the county archives and Tom Ogden's team over there to try to solve issues. Two things, most of my comments are somewhat reactionary. I didn't have anything planned, but two words come to mind: service and trust. Those are two terms that have come up with previous speakers, and I agree wholeheartedly with Steve Kaufman and Tom Britt and what they had to say about access to these records and how vital that is. And the comments on trust combined with that, you won't have public trust unless you are open with what you're doing in leadership. And that's the key that I think is being tarnished by this attempt to add additional charges. We do charge for copies, and I know most institutions that I'm aware of do charge to some degree for copies. It's my experience that the average person does not worry about that too much if you have to pay for a photocopy. But what they do worry about is the service you give them, and any kind of encumbrance or blockade to accessing those records. That becomes frustrating to everyday people. And I think that that's what we need to avoid. That's what we certainly seek to avoid. By example, one of the most outstanding experiences with service to a person coming out of town to our facility, asking about material regarding their genealogy. It's not as critical as some of the issues that have been brought up today, but to that person it was very important at that time. We discovered through consulting and looking at our materials that where we needed to go was to the federal building, the federal court building, and I knew Ed Bryant, who was there, and I called his office. and I asked him if there was a way for this person to seek those records where he was, and he said yes. He said, you send them over here, I will meet them in the lobby and escort them upstairs, which I got in my truck and showed the person how to get to the building, walked with her across the street to the door, and Ed Bryant was there to take over the next shift, and he conducted her, and we got a glowing phone call from this lady a week later or so, how wonderfully she was treated here in Jackson, Tennessee. And I think that's what we need to be doing, all of us that are in charge of public records, that are in charge of any kind of record, whether it be newspapers or even private collections. It's all about service and trust, and the comments that Mr. Tinkle made earlier are the types of comments that are rewarding to me as a public servant, and I would like people to say things like that about me. So, thank you very much.
I'm John McCutcheon from Jackson, Tennessee. I'm involved in a number of leadership positions with some 6 genealogical societies that I'm representing here today. We would certainly be opposed to any restriction on access to public records. In order to do genealogy, you need to be able to determine death records, marriage records, wills, deeds, etc. I can only echo all the comments that have been made today. I don't think I've heard from one who has said, yes, we need this tax, we need to put restrictions on top of public access. So in order to be brief and let Lonnie come up here with the Tennessee Historical Commission, I concur with the comments that have been made, and we would be opposed to any of the proposals within this legislation. Thank you.
My name is Lonnie Harris, and I'm a member of the Tennessee Historical Commission, and I did not come prepared to speak, but I would like to ditto what Jack Wood and John McCutcheon say. My stance is basically from a genealogical perspective, and it can be a very expensive hobby just paying for your copies. But if we have to pay even to view and to enter the libraries and archives, I think we need to keep this open for everyone, because genealogy has become something that people on all economic levels are interested in. And so that's my main objection, is isolating people who, this is their family, this is their history, and we are all entitled to that information. Thank you.
Several people whose names were called did not come up. I just want to verify at this time that anybody who wished to speak or wishes to speak now, even if you didn't indicate in the beginning, see.
Sorry, I think you called my name and I just listened.
My name is Larry Wood. I'm the general manager of WNWS FM in Jackson. That's News Talk 101.5 FM. We are in the news business, and this is important to journalism, but it's much more important to the general public. It's not about media companies not wanting to pay a fee for information. I mean, certainly that's important, but it's about the ability of the average citizen to have access to the information. Journalists give the public access to that information, and so that's why this is so important. The government's creation, maintenance, and availability of public records is a right of the citizens who own them. And so that is our concern, about the citizens who already own these records and do not need to pay again. So the public access to the records is by the people who already own them, and our job is just to, as journalists, is just to help pass that information along. But it is just absolutely wrong to limit access to the public records. Thank you.
my name was on the list of speakers, but I think they did what I had to say a lot better than I could.
Sir, are you sure you wouldn't want to come up and just affirm?
I agree with all of the opponents said.
Yes, sir.
Thank you. My name is Ken Welch from Memphis. I spent 14 years in television news, and since then, for the past 25 years, I've been in information technology, both of which lend some knowledge to the need for this open records. State law should not permit record custodians to charge for inspection of public records. I'll agree with another respondent that if the law should be amended to permit such charges, those fees should be established by the state, preferably by the General Assembly, as a flat rate. I think also copies should be done that way, so we will have a standard. Certainly, if charges are permitted, inspection of meeting agendas, minutes, audit reports, and any presentation presented in electronic digital form at such meetings should be exempted. Charges for inspection are permitted if they should be permitted. As I indicated, the General Assembly should set a flat rate. TCA 84604 allows for far too much variability and therefore the possibility of abuse. Charges for duplication of records should be minimal, and I will outline in a moment why duplication by the custodian of records or that person's designee should become rare. I take the concept of self-government seriously. It's what our state and our subdivisions of the state are based upon, and I hope we all do. To effectively govern ourselves, we must be well informed. Any barrier to access to government records diminishes the ability to govern ourselves wisely. In this technological age, we are afforded the ability to make most government records available without the need for specific requests for government-based labor-intensive searches or for duplication costs. Most records are now created in electronic digital form, that is to say, on the computer. It's time for a new paradigm. Except for records made confidential by law, all governmental records created in electronic digital form should be made available to the public at the time of creation, and they should be made available via the internet. Third-party entities can index or provide search functions for public inquiries. If personal assistance is needed, research librarians in our public libraries are already trained and prepared to provide service in that regard. The era for government employees to spend time identifying, finding, and providing responses to specific requests for public records should be drawing to a close. As we move towards this new model, the need for changes for individuals to seek public inspection should be alleviated. This is the underlying reason, among many other good ones, our General Assembly should not adopt charges for inspection of public records. Thank you.
Is there anyone else who wished to exercise rights to the 5 minutes? Well, I would like to, and Mr. Dunn, I think, is going to come up with me. I would like to thank all of you very much for taking time out of your busy days to come and express your positions or to listen to this issue being discussed. We, as was mentioned earlier, we have the survey up online, SurveyMonkey survey. If you are involved as a record custodian, we have a link for that survey. We have one for citizens, which includes media representatives. Also, we have the 5 questions that were for today's hearing. If you made comments today, if you could please submit those to us in writing, that will assist us with that. And I believe John's going to go over some other points.
Yes, and just as a reminder, you still have the opportunity to comment via email. And just once again, that email address is comments.open.records@cot.tn.gov. And both the email to receive those comments and the surveys will be open through, again, September 30th. Just as a reminder, the audio recording of today's proceeding will be on YouTube, hopefully by the end of tomorrow. And we just ask that as you leave to remember to turn in your visitor tags, if you could, to the security. And I just want to say, Paul, you warned me that there would be hooting and hollering, and I didn't hear any of it, so that all turned out very well. And again, we thank Senator Jackson for being here today. Thank you all so much for attending, and we'll see you again soon.